Now, oftentimes when we're talking entrepreneurs, they often don't have a basic estate plan put in place. But when we say basic estate plan, what are the documents that we're generally referring to?
Yeah, well, typically they're going to need a last will and testament. They're going to need a living will. They're going to need powers of attorney, both for financial and health care. And then, guardian designations and a living trust or a revocable living trust. Those would be kind of the big building blocks of everything that you would need. And if we just start real quick and run through these, a will is usually, for most entrepreneurs, if they have a living trust, which you should probably have if you have any assets at all. But if you have a living trust, it's usually a pour-over will. And that just tells a judge, because a will is synonymous with probate. If you have a will, the will goes through probate. That's why you get a trust, is to avoid probate, among other reasons. So you'd have a pour-over will, which would just tell the probate judge, hey, if I forgot to put something in the trust, I meant to put it in the trust, would you pour it over into the trust, right? If you title things correctly, which I would hope entrepreneurs would, then you don't have to worry about that. But the most important thing other than that for the will is designation of your guardians for who's going to take care of your kids. And I would imagine you've got your people listed out for who's going to take care of your kids if something, God forbid, happened to you. A lot of people don't do that. And then it may be the worst person in the family who steps forward that would get the responsibility from a judge to raise your children. So you have to have that in that basic document that's a will.
Yeah, well said. And let's move on now to the powers of attorney.
Yeah.
So I think the powers of attorney are two different documents. You're going to have the durable or financial power of attorney, and then you're going to have the healthcare power of attorney. And the way that I like to describe the durable or the financial power of attorney is going to be any assets that are not governed or owned by the trust. If you were incapacitated, who can step in and manage those assets? That could be a business. That could also just mean someone signing on your behalf if you want to close or sell or buy some real estate. But again, if it's something that's owned by the trust, then the successor trustee is going to be able to step into the shoes there. But for anything that is not titled appropriately, or if you don't have a trust, that's where the durable or financial power of attorney is going to come into play. And one of the key decisions you need to make when you're putting a power of attorney in place is, do I want this to be durable or do I want it to be springing? And there's some pros and cons there. And I'm curious to get your thoughts on that, on what you think is best for most entrepreneurs.
Usually when you have a stable marriage, you would want your spouse to have the durable power of attorney. So Mimi has my durable power of attorney. And I guess just to step back a second to define those terms, durable means it's already active. So if Mimi wants to use the power of attorney to sign for something, she can do that. A springing would mean there has to be some sort of triggering event. So that could be two doctors say, I can't make my own decisions. Now that springs into action. So with a spouse, usually durable. But if you were a single person and you had kids, maybe you want it to be springing if you're not sure that you want to make sure your kids don't just start signing stuff in your name using the power of attorney without your permission. So you have to make that decision based on your situation. But those are the two, springing and durable.